15 for 15. I am your host, John Zalkin from RKW Residential. 15 for 15 is a new and exciting video series where we interview 15 influential real estate people for 15 minutes each, where we get their perspective on what's happening in real estate during COVID-19. A little bit about RKW. RKW Residential is an award-winning third-party multifamily property management firm with over 20,000 multifamily units under management and a growing footprint spanning 6 states. RKW delivers expertise in multifamily management through its technology, marketing, and customer experience platforms. My guest today is Robert Zarco. Robert is from Zarco, Einhorn, Salkowski, and Brito. Robert is the founding partner of that law firm, which serves the rights of clients nationally and internationally in complex legal business disputes, litigation, and transaction. Robert has earned national and international recognition in the area of franchisee litigation by representing franchisees throughout disputes involving major franchisee systems, including over 500 brands such as McDonald's, Burger King, Dunkin' Donuts, 7-Eleven, Arby's, KFC, Coca-Cola, PepsiCo, Holiday Inn Hotels, Best Western Hotels, Quality Inn Hotels, Ramada Hotels, and like I said, hundreds of others. Robert, it is great to see you, and thank you for taking the time to join me on this episode of 15 for 15. I'm really excited to hear what you are seeing involving the landlord and tenants, and just to get your thoughts on the overall how things are going. Can you please just briefly expand on your bio and then tell us what you are seeing in the markets today?
Thank you, John. It's my pleasure to appear before you today and for the audience who gets the opportunity to watch this video. I have an extensive background in representing franchisees throughout the country and internationally, as you said, in over 500 brands, over 40 states and over 23 countries. And through that time, I've also gained a tremendous amount of experience undertaking major real estate transactions, representing developers, representing landlords, representing tenants in disputes that range from a simple landlord-tenant relationship to much more sophisticated multi-unit development projects, and including hotels. Throughout the 35 years of me being a lawyer, I have had the opportunity of being exposed to a lot of circumstances, whether it be cyclical changes in the economy or other kind of effects on business relationships between franchisor and franchisee, as well as landlord-tenant and landlord and developer, and the interaction of all those relationships, which have given me a lot of insight and experience as to what's going on today. The reality that today is that with the onslaught of COVID-19, it has had an unprecedented impact on the real estate world, specifically in relationship between landlord and tenant and landlord and financial institution. The most predominant problem that we're having is that as a result of these civil action mandates by the governmental authorities requiring properties to close down, requiring businesses to close down, whether it be hotels or restaurants, it's having a tremendous impact on hourly workers, where people are simply unable to continue to pay their monthly rental obligations to the landlord, including the businesses themselves. A restaurant is not unable to pay the mall owner, or the restaurant is unable to pay the owner or landlord of the particular out parcel in which a restaurant is located. A hotel owner whose occupancy has gone from 85% down to 5% is unable to pay a landlord if it's a long-term lease, or able to pay a developer, or able to pay a financing institution. So it becomes a domino effect in terms of, where does a person's rights start and where do other people's rights correspondingly start, which means the initial person's rights end. For instance, if a tenant does not pay rent because he's unable to do so, what is the landlord supposed to do? Does the government have the right to tell a landlord, you simply do not have the right to go and pursue a tenant to pay you an obligation? And the reason that there are questions of constitutionality of that is because the government is in essence jumping in and interfering in the landlord-tenant relationship. However, there are provisions in the contracts between the tenant and the landlord, which deal with force majeure, acts of God, and other major occurrences that are unforeseeable and not within the control of the tenant. Many of these provisions create and establish what's called the contract defenses, such as impossibility of performance of your obligations or frustration of purpose. There are legal doctrines that specifically indicate that if, as a result of a governmental intervention in a business that was not contemplated and falls within the consideration of a force majeure provision or an act of God, that event will create an excuse for the performance of the tenant from having to continue to pay the rent to the landlord. Now, that is a very contract-specific issue. In other words, these enforcements of these force majeure clauses are creatures of contract. Not all contracts are created equal. Not all contracts are written the same way. And the application of these defenses, the impossibility of performance or frustration of purpose, play a big role in what's going to happen. The concern, though, is what happens to a landlord that is not receiving his rent. That's going to be the big trigger, because the landlord has also obligations, and the obligations are to pay the mortgage. There are common area maintenance expenses that a landlord has that has to continue to be invested in the property, otherwise the property will turn into shambles. And now the landlord is getting pressure from the lending institution in which financed and funded that landlord's business. And then at that point, what is the obligation of the financing institution to give deferrals or abatements or reductions in interest payments or defer principal payments on these obligations? So it becomes very, very complex. The law at this point is not well settled on this. You have different states that are establishing legislation to address these issues, and you're going to have a lot of lawsuits that are going to arise where different courts are going to be making different decisions, where some courts could be stepping on the toes of other courts, where the decisions across state lines or even across jurisdictions within a particular state could be very different.
Robert, let me interject. I mean, that was amazing. I knew when I got you to come on here, I was going to get a lot of information and a lot of high-level, high-detail stuff, because I know you are one of the preeminent guys who do this in the industry. Regarding force majeure, if I'm a landlord and if I'm a tenant and I use that clause, am I allowed out of my lease, or is it only just not to pay rent? Can I cancel the lease with that clause?
That's a great question, and a lot of people misconstrue the effect of force majeure. When the force majeure clause in a situation like this gets applied, you have to consider whether the force majeure is one of a permanent nature, or is the force majeure one of a temporary nature. COVID-19 is going to be a temporary impact kind of situation. It's not going to have a permanent effect where it's going to exist forever. Or if it is going to exist, it's going to be no different than the influenza flu, which is the one that really kills people, and is forever in our country and in our midst. But that is not deemed to be a basis for not performing under contract. So COVID, in my view, is a temporary suspension. So frustration of purpose is typically designed, for instance, if you have a property and there's a fire and the property gets completely destroyed, and for some code reasons, there's a local zoning ordinance that precludes that property from being rebuilt. At that point, that is a permanent force majeure, and it will excuse performance of the entire contractual relationship.
Gotcha.
Under COVID-19, it's a temporary suspension. What's going to happen is you have to figure out how long it takes to restore the property to the condition it was in, or the condition of the community or the economy in which that property is operating before that force majeure defense expires. So I think realistically, tenants need to expect that to whatever extent a landlord who wishes to work with the tenant, or even a landlord that doesn't wish to work with the tenant, but however a court may be inclined to give you some leeway, you're not going to be getting much more than 2 to 3 months. And at the outside, I can't see more than 5 to 6 months of reprieve. Now, the reprieve comes in two forms. Is it a reprieve in the form of an abatement, which means a forgiveness of the rent for a particular period of time? Or is it one in the form of a deferment? A deferment simply means that you're going to pay the rent in full, but you're going to pay it down the road. It's like kicking the can down the road for an obligation that existed today that you're going to have to pay later. With regard to an abatement, the argument could be, well, I did not operate my business in the building or on that property during this period of time. That means that because of the impossibility of performance defense, which I discussed earlier, or the frustration of purpose defense, which I also touched upon, it is possible that a court may find that the tenant may have no obligation to pay rent during the time period in which the building was closed. Now, interestingly enough, you have to differentiate where a building is actually closed for business and a situation where business remains open at the discretion of the tenant to come or not come, pursuant to a stay-at-home order in place. There are situations where tenants, even doing stay-at-home orders in place, are operating businesses which are considered essential, and therefore they have to go to the location to do their work. The problem is that typically, because of the general condition of the economy, the amount of revenue being generated by those businesses is a lot less, in fact, a small fraction of the revenue that was generated earlier. So now you get into, nebulous arguments here, and creative legal strategies have to be utilized to say, well, I recognize that I was physically present at the property. However, I do have my clients who would come here that now cannot because of stay-at-home order, or my vendor that provides me with all kinds of business is no longer being able to operate their business. Therefore, my revenue and my source of income has gone down. So how does that play into my obligation to pay rent? Very vague, not clear, unprecedented, and there's going to be a lot of litigation arising from this. Now, another thing that the landlords are going to consider are, why are you not paying us, who's the landlord, and we have a provision in the contract that says even under some unforeseen circumstance like a pandemic or an act of God, you have a continued obligation to pay us. Why don't you go get the money that you owe us from your business interruption insurance policy? Well, that's another argument. So a tenant cannot get a windfall by collecting business interruption insurance payments from an insurance company, assuming there's coverage, which is something that my firm is now specializing in proceeding to represent a lot of people that are insured under business interruption policies, but who are not getting paid or whose claims are being denied. We're taking that upon ourselves to help the many, many hundreds and thousands of people that are in the situation. But what happens when, in fact, the business interruption insurance company pays for the expenses incurred during particular months in which the tenant says, no, I'm not going to pay the rent? Well, that's a windfall. And that is not the intent of the courts when they say, all right, you don't have to pay your rent for now, you can defer it. And that's not necessarily the intent behind the impossibility of performance defense. Yes, it may be impossible to perform, but if, however, the business interruption policy is paying you for lost rent, it is only legally appropriate that that rent be passed on to the landlord.
It's really amazing. I mean, I could sit and talk to you for hours about this and everyone who's going to be watching this is going to be blown away because the details that you just gave through and the sophistication of it is fascinating. As I say to a lot of the people, I'd love to have you back on in a few weeks so we can kind of get an idea of where everything is falling into place and how things are actually proceeding. But
yeah. And John, I would be happy to. And there's so much more information that
I think I need to do a part
tell
two.
you.
Yeah, I think because there's a lot of things I wanted to touch on with you regarding hotels. And I know you're in contact with everybody, so I may hit you up for a part two. I know you're just a little bit busy in your world right now, but I'd love to. But I like to end with a fun little question and answer called the lightning round. So you ready to have a fun little lightning round?
I'm always ready.
Perfect. So these are yes or no or over and under questions. Does the 10-year treasury close over or under 1% at the end of this year?
Under.
The next time you're on an airplane, over or under 90 days?
Under 90 days.
Next time you attend a networking event, over or under 90 days?
Under 90 days.
The next lunch or dinner at a restaurant with a client, over or under 90 days?
Under 90 days.
I like the optimism. Is the election going to be suspended, yes or no?
No, it will not.
Will Trump win or lose?
Absolutely will win.
Does the stock market end over or under 20,000 at the end of this year?
Over.
Does the U.S. COVID-19 infection rate go over or under 500,000 in the U.S.?
I'm sorry, repeat that?
Does the U.S. COVID infection rate go over or under 500,000 cases in the U.S.?
Infection rate or deaths?
Infection.
Over.
And last but not least, do you think you will be on a vacation in the next 6 months?
I hope to be on a vacation within the next 10 days.
I love it. I like the optimism. We need that today. Robert, I really want to thank you for joining me on this episode of 15 for 15. It was more than I could have imagined. Thank you so much.
Thank you, my friend. I'll do it again whenever you need.
Absolutely. Everyone, we hope you all stay safe and practice social distancing and make sure to wash your hands. If you have any questions or would like to find this video, please visit rkwresidential.com.